All right. So welcome to a special divided class of video game law. This is also going to a number of UBC law students who are in another room and watching through an Oculus Rift. For those of you who are here live, I'm going to be probably a little more restricted in my motions because I've got to stay within a certain space, although I can move around. Last I saw this, even in virtual space, this is truly a law course because even in virtual space, nobody's sitting in the front row, which is endlessly amusing to me. All right, so today we are near the end. The third and final class of the controlling meme. So we've gone from creating to connecting to controlling. And this is essentially, this meme is about can you put the genie back in the bottle? What measures and countermeasures are possible? And where does the law intervene? Does it intervene too much? Does it intervene not enough? First step was talking about copyright and originality. Second step under controlling was misogyny and violence and Gamergate. And today we're talking about privacy and surveillance. I should mention that when we rebooted the course into its kind of current 2.0 version, there wasn't a whole lot that seemed obviously part of video game law in terms of privacy. I mean, there were some issues. Mostly there were concerns. And very rapidly it turned into my thickest file and even thicker than the violence and sexism file. We heard earlier at the beginning of the semester sort of advice to you that if anybody seriously wants to become part of the industry as a lawyer, privacy is where there seems to be no end of issues. Having said that, I will give you one caveat. There are no easy answers, which is why there's no end of issues here. So this is not one where I can even pretend to wrap it up in a neat theoretical bow. This is really a class of questions more than anything. Mentioned already that we've got a divided class. We'll see how that goes. The video of what the students on the Rift see will also be posted on the website, so you'll be able to spend a few minutes with that. Term papers, we're getting really, really close. Almost everyone has contacted me. If anyone hasn't, please do. All of the coordinates are on the syllabus on the course website. Want to point out one thing. When Jennifer Kelly was here 2 weeks ago, she alluded to a lawsuit that she was filing, if anyone recalls. This is the lawsuit. It's against a Vancouver company called Hothead Games. Jennifer is acting for Glue Mobile, who does Deer Hunter, and the lawsuit against Hothead is about a game called Kill Shot. It's interesting to go through the pleadings. There are a number of stories that you'll find on the web, and apparently even mistakes in Deer Hunter were replicated. In Killshot, on the other hand, in Killshot you have a situation where the skin of the game seems quite different. So you'll see different perspectives, and for those of you writing papers on originality, certainly this is the cutting edge lawsuit, and I don't know how much more we'll hear by the end of this course, but certainly we'll hear a lot more about this in 2015. So privacy is a tough one. We are really, when we're dealing with video games, because we come from originally from sort of a single player hard disk modality for so many years, privacy was never a huge concern, and at least in terms of gameplay. But in recent years, it's become a very obvious concern, and we'll talk quite a bit about how and what's caused that. But I'll just point out that we've got a Connect 2.0 for the sake of the Oculus that's right in front of me, and we have a bunch of people in another room watching me. Now that's all by consent, but it gives you a sense of the power of the technology and what happens if, in theory, it's not by consent. This is not a difficult setup, as you can see. So the threshold question that seems to come up with university students is, do we care? Do you care about your privacy? There are, and there have been in previous iterations of this class, any number of people who would put up their hand and say, well, no, I don't care. For one of two reasons. Either I'm getting what I want, and it's a trade-off, and I'm a realist, so that's okay. And then there's, I'd say, a smaller minority who go to, well, I've got nothing to hide, so what does it matter? I'm just curious, in this room, how many people would say that privacy is important to them in playing games? Let's put it in a games context. Okay. Let's see where you go. So let's, just to iterate back to the connecting part of the course where we started laying the seeds for consumer protection and where it's going, the Kim Kardashian game. Remember, we talked about this article, and the question was whether it was too easy to confuse what a player might think is a fake Twitter account in-game with the real Twitter account that the game triggers you going out on. And it's this sort of thing that when you look at privacy in games, think about it in these terms. Think about people seeing what you're doing, even if you don't necessarily want them to. Not that I would ever suggest that playing the Kim Kardashian game is an embarrassment to anyone. Far be it for me to say anything like that. Obviously, it's big data that's getting us there, but it's also bad judgment. Now, this is outside of games, but you might remember Facebook's experiment, sort of A/B experiment, where they showed different people different data, to see what the scientific results would be in terms of reactions. And actually, it was published in a journal. And nobody seemed, the most troubling thing of the whole exercise was that nobody seemed to catch it as being a problem until the public caught it as a problem and started wondering, hey, are you doing this to me? And then the additional complication that we've always touched on, what about the kids? So as soon as you start implicating kids and privacy, you basically scaffold it to the next level. And you start bringing in, or regulators bring themselves in. I would argue rightly. Others might argue not. Let the magic circle, let the free market, whatever you want to say it is, apply. Or, I guess the other free market approach is let the lawsuits prevail. Now, the regulatory approach is worldwide, and we will have Jaz Purewal in the second half of our class today coming to us from London, England, and he's going to talk about a series of international law issues relating to video gaming. More international, and finally, you've heard this before, what happens when the Oculus is actually got sensors and is measuring your brain and potentially, with your consent, affecting your brain in one way or another to give you a better experience. What happens then? What happens if that gets hacked, et cetera, et cetera? So the issue of privacy, I guess this is the real take-home value. The issue of privacy and the issue of surveillance are essentially the same issue. They are flip sides of the same coin. And in previous years, in a pre-Snowden world, I tended to explain them as two separate things. And I would say this is the first year where I say they're actually one thing that you look at through two different lenses. They've merged. And just so you know what we're looking at is this is a diagram of the GPS satellites around the world and where they are in geostationary orbit. The real point being the satellites aren't actually moving, but the Earth is, as I understand it. But it's a much more interesting graphic. There are lawsuits to figure out the extent of surveillance. But again, surveillance is no longer a standalone word. And in a video game context, it's useful just to briefly go through a small timeline, because all this happens very, very quickly, of the merger of privacy and surveillance. So not that long ago, a little over a year ago, this is a really interesting piece, and not the first one, but it's an interesting piece that points out that video games are part of what makes us comfortable with surveillance. Because in the context of games and multiplayer games, we in effect surveil each other. And I'll show you a little bit more about the dynamic of that. But then we got here. And this was one of the Snowden revelations. And there's some very, very funny pieces online which you can look for yourself. But the NSA was actually in World of Warcraft on a covert mission. I don't know what to call it. And the more cynical, there's at least one cynical strain of critics who said that basically a bunch of people in the NSA wanted to play games, and this was a good excuse to do it because, as far as anyone knows, there hasn't been any documented success that came out of that covert online mission. And it does appear like there was a fair bit of resources. Now, all of this becomes very murky, but it's endlessly amusing on one level. On a more serious level, here you go. Privacy, surveillance, one thing, not two different things. And this is an interesting piece because it's an academic piece that, if you're doing a paper in this area, you want to look at it in a fairly methodical way. Just explains how the structure of games accommodates the structure of surveillance and the incursions on privacy. Taking it to a really base level, and this really comes from the paper, just reminders of the in-game artifacts that facilitate breach of privacy / surveillance. We've been watching each other for ages, right? Scoreboards, achievements. You get a fairly good sense of how much time somebody spends on a game, how good they are at it. Multiplayer itself. Now, I've never played a game, I've never spent enough time in a game other than Grand Prix Legends to really know how other multiplayer players think and operate, and in order to make a judgment on them. I certainly, during the time I was spending much too much time with Grand Prix Legends, I certainly had a pretty good idea of certain other racers and how they drove and which ones I would want to drive with on city streets and which ones I wouldn't. But because of the nature of the game, it was a fairly limited experience. Although, I had a fair bit of data because there was also voice at various times. So you get a pretty good idea of a person if you're just lurking within a game context. Now, of course, we've got spectator mode. So you don't even have to play the game to watch people in the game. So if you are the NSA and you want to be snooping, the full modality is right there for you to do it. We have Connect, which gives you all sorts of information, and will give you my facial expressions, et cetera, if the software is there to translate it. And then we have something really interesting for those of you who have a PlayStation 4. There's actually a share button on the controller. It's up here. And it really allows you to send all sorts of things out on the net, whether you're streaming or otherwise. So, and that sort of mode and modes are simply going to grow over time. And anybody here have a PlayStation 4? Okay. Anybody go and check out sort of the live videos that are streaming from various people's homes at various times. It can be really, really odd. But you also get a real sense of who you're dealing with and where you are and whether you're in a dorm room or not. And if you cross-reference that to other information that's online, you can probably get a fair bit of information. So we've set the stage. What do we need to look at and think about from a legal perspective? Let's start small and local. So what does the Privacy Act say in British Columbia? It essentially creates a relationship between what a person's reasonable expectation of privacy is and the level of privacy that should be accorded to. It's a very nice test. I'm entitled to the level of privacy that I expect. In very simple form. What do you do with that test in an online setting? What does it mean? Just because you go online, does that mean you expect all your information to be available? How do you apply that test? When you play a game, what does it mean? And how much choice do you have? Who gives you the choice of how much information is to be shared? And is it really your choice? And you guys know the answer to this question. The answer is, at least in the game context, and probably in most online contexts, it's set by the end user license agreement and the terms of service. So, paper idea, paper point, how do you reconcile traditional notions of privacy that certainly make sense and have made sense with the digital world, with the online world, and with the in-game world? And I'd say those are three different levels. Then there's the collision of rights problem. And that is, what do you do with privacy versus free expression? What happens when those two rights collide? And we don't have a great case in Canada in terms of the online world or the video game world, for sure. But we have a Supreme Court of Canada decision, so that's better than eating crackers, from 2013. But it has to do with old technology, videotaping by a union of those crossing the picket lines. Now, here's the difficult part. They suggested they might post those videos online, and they never did. And the Supreme Court said the union had the right to take those videos and have those videos and use those videos for their purposes. They didn't have to decide whether it would be okay to post them online or not. And in this limited way, free expression, the union's right to free expression, trump the privacy rights of those who cross the picket line. It's hard to take too much from this case and apply it to our world, but it's there, and if you're writing a paper, you need to know about it. So section 2B1, But we have all of the balancing language that you come to expect and have come to expect in from your constitutional law course in this realm. And you essentially, if you're writing a paper in this area or thinking about this area, would have to write your own Supreme Court of Canada decision to see what you're going to do about the Section 2B, Section 1 Balancing Act in light of privacy. So conclusions on this are very tentative. And the first one is that privacy is not an absolute. I think we know that. But it's become a highly malleable concept in the digital world. And we really have not figured out how to put Humpty Dumpty back together again. And that's why the advice in the first or second class was, if you're going to go into any area, go into privacy. Because it's going to be a dialectic for the law and within the law for quite some time. All of this becomes very complex in a commercial environment, which video gaming largely is, because freedom of expression is being invoked by the developers and by the distributors. The one concept that we can hang on to as being useful is the notion of express consent. However, what does express consent mean in the context of end-user license agreements and terms of service, where express consent is being given knowingly or not? So, what can we reconcile here? What are possible ways forward? And this is even more tentative than the previous conclusions, but just to give you some things to think about, as opposed to answers. But if you, we may, or you may find, I have far greater hope for you finding it in your time than old guys like me finding it in the near term. So what's reconcilable? Moral rights. Moral rights is an interesting piece. It's an intellectual property piece, but, and we've talked about it previously at some length in the course, but remember it has to do with the concept of integrity and integrity of your work. So maybe if you can transpose that onto integrity of your information and your right to control whether you're associated with your information or not, it may be a useful concept, because you can almost map moral rights onto privacy and get something useful and interesting, because the core concepts make sense. And that takes you to the right to be forgotten, which is being implemented in Europe. There's various levels of criticism of it. It's very hard to implement. I'm going to be talking to a colleague who wants to write a paper on the right to be forgotten and how to think about it in journalistic and legal terms this afternoon. So it's a bedeviled concept. I'll point out that it's not inconsistent with moral rights. And that neither of these concepts do badly if you put them against a kind of post-structuralist interpretation, because, as has been discussed at length, at probably too much length for your liking, it's about the gamer, it's about the individual, it's about the rights of the people who not only participate, but actually create the game, pour the wine into the bottles. And so in that context, thinking of privacy and thinking of the freedom from surveillance, certainly surveillance you don't know about, which is the definition of surveillance, in my view, makes some sense. And there's one other concept I think may be useful here. And it's an old concept, freedom of thought. This is the current iteration of J.B. Bury's book, which is a very old book called Freedom of Thought, A History. I've chosen the far more dystopian cover that I found online. And I'll point out that it's available as a free ebook. So if you're interested in this area, it's easy to get. And freedom of thought has generally been about freedom of religion. And it's sort of halfway between freedom of religion and freedom of expression. And Bury occupies well that middle territory. Please do read the book, because these aren't the only two important passages if you're interested in this area. But sort of given you a very, very short form of what's the question and what's the answer here. So the question, the problem that Bury wrestles with is that governments have a tendency to argue that it's their responsibility to prohibit the circulation of pernicious opinions. And as you will read, that kind of knows potentially no boundaries. And Bury's answer as to why freedom of thought is important is that, after looking at things for 165 pages, if the history of civilization has any lessons to teach us, it is this: there is one supreme condition of mental and moral progress, perfect liberty of thought and discussion. It's my suggestion that freedom of thought is potentially going to be an extremely important concept in a world of surveillance, in a world where privacy is the issue, in a world where people through big data can reach all sorts of conclusions about you and potentially manipulate you. Why? Because expression is aligned with, if you're expressing yourself, and this is kind of the classical argument that you would find in a digital commercial concept. Well, you're choosing to go on Facebook. This is stuff you're putting out there. Don't tell us, the government or anyone else, that we don't have the right to look at what you're doing. You're doing it. Where freedom of thought is interesting is that it goes right to the kernel of what's truly private. And if freedom of thought really operates, then without expression, nobody should have a right to know anything about you. And yet they do. So how does that get reconciled? So I have a suggestion that freedom of thought be used, be resuscitated as a legal tool in looking at these issues and pushing through them. Also, freedom of thought gives us another, I think, reinforcement of the post-structuralist argument, and that is that the freedom of your thought and the freedom of my thought are not going to be the same. Our thoughts are not going to be the same. How we define the freedom is not going to be the same. We're all different. We're all users of the concept by being human. Just some stuff on the right to be forgotten. I will make one comment on Article 16. And you guys will do much better than me if you're looking at this in terms of a paper. It is really, really hard to find the actual locus of the right to be forgotten. The document is painfully obtuse. I'm sorry if I'm insulting the drafters of it. And sort of how you get there is really difficult from a legal structuralist perspective. As law students or as lawyers reading through, it's not like, oh, there's a right to be forgotten. It's not nearly that simple. It will cause you some pain if you're writing in this area. The case, however, that created so much kerfuffle is interesting. It's an individual who wanted the removal of web links to an article in a Spanish newspaper about an auction for his foreclosed home, and he had subsequently paid off his debt. And therefore, when you looked, if you Googled this individual, the first thing that came up was this implication that he had not paid off his debt when in fact he had. And so ultimately the European Court of Justice said he had a right to be forgotten. How far does that go is the question in a Canadian context. It's awesome paper. Would the right to be forgotten survive Section 1? So when you look at the Oakes test, when you look at our balancing act, what would we do? And that's a complete unknown. I mean, this is, now, if you're going to turn it into a paper, you have to bring it back in some way to a video game context, but that's not really hard to do. And in my case, do I really want my times from Grand Prix Legends at Monza, in 2001 to ever be seen online? It's clearly defamatory of my abilities. In any event, sorry, couldn't resist. So I'm working backwards here, but just to give you a little bit more detail on what this looks like. So then we have the moral rights piece. And this is from the Copyright Act. Just a reminder, the right to the integrity of the work. And we're reasonable in the circumstances, which people almost always forget to read, to be associated or not associated with the work. Not clear what reasonable in the circumstances mean. There's kind of one other concept. It's hard to know what to do with this one, but it's a very important one. And that is, let us not forget that law itself can be reduced to code. And we could actually build the rules into the software. So we could build the rules of privacy and surveillance much more so than we have, right into the devices, right into the programs we use. Should we, shouldn't we? Ultimately, I bring us back to McLuhan because he, in a small way, gives us the answer to our confusion without taking away our confusion. This is a tautology. Games are models of a culture, and our culture is confused about privacy and what it means in a digital age. So our games reflect that confusion right now. Our digital world reflects that confusion right now, because our culture is confused. So right now it's a bit of a vicious circle. How do we break it? What does privacy mean in games? And again, here's where that's as close, we've gone as close to finding answers as we're going to. Now I'm just going to remind you of some concepts. Games have always wrestled with the question of identity. Video games had avatars right from the beginning. I mean, it's incredibly fitting that I'm appearing as an avatar to another classroom in this law school right now. This is a game technology right from the beginning. And we've always had confusion about what that means. And I'm not going to give you the post-structural answer, but because we've already explored that, but the question of what is the avatar, what does the avatar mean, what does it mean in terms of the magic circle and law are questions we've explored. Another issue. Video games have had community for a very, very long time. In your mind, does having community mean you don't want privacy? And to go to the traditional notion of what privacy means, what does a reasonable expectation of privacy mean in the context of an online community? Do you have no expectation of privacy when you join a community? Or do you have some? I do. I have some. I think there are rules of the road. But that's the core tension. And when you play a game, if you join, if we're friends, I get to know what games you're playing and when in a PS4 and a Xbox One context, if we're friends online. Now, I've consented to that. You've consented to that. There are not nearly enough sliders to control. I don't know how many people I want to know exactly what I'm doing and when. I'll simply point out that my son, who plays a lot of video games, has never chosen to be my friend in a video game context. And why? Because he knows that I would say, well, what's happening with your homework? Don't you have an exam next week? So these are real issues. The key difference, I talk about privacy and surveillance is the same. The one obvious difference is that privacy is, at least in theory, I should have put in theory, a negotiation through your end user license agreement. There's no negotiation in surveillance because you don't know about it. The two are often confused. And this is, you've seen this layers of control slide. I just want to give you a sense of how pervasive. I've just tried to identify where privacy and surveillance issues show up. And I may have missed some of these, but, you know, sort of fully half of the layers of legal control directly implicate privacy and surveillance. And the problem is growing. We've talked about telepathic games and how serious that can be. And I'm not sure I showed you this before, but this is, I alluded to it. So I wanted to find the actual article. This is from MIT News from over a year ago. Neuroscientists plant false memories in the brain. So this is how far it can go. I'm not going to go through this because we don't have time, but this is just a map for when you're a creator or a gamer, what happens, what are the layers of information that you're providing. And the two moving forward questions, what happens to the magic circle? And I was somewhat comforted by the show of hands earlier. Is this even an issue to the digital generation? It seems to be. There's a Pew study, a mini Pew study that came out just today, so it'll be in News of the Week, that tends to show, yes, people are concerned about privacy. And there was some thought previously that really it wasn't that big a deal. I'm just here tracking through on a surveillance side so that you can see some of the law with respect to search warrants. And I just want to spend a little time on this slide. And this is, and I'm not picking on Sony, just an example of their privacy policy from 2011, and this is the actual wording, where and to the extent required by the applicable laws, you hereby expressly consent to your personal information being shared with or otherwise transferred by Sony Online Entertainment to third parties. Really, the lawyer on this did a fabulous job for Sony, not for you. Sorry for the small type. I really do want to send you to this article. Evgeny Morozov, who is rather controversial on many things and who I don't necessarily agree with on many things, wrote a wonderful piece on privacy, saying essentially the law is only of limited help. This is a political issue, and it needs to be solved politically. And we must learn how to sabotage the system. We must learn to not self-track, and we need digital services that come through and protect our privacy as a competitive advantage to them. And we're starting to see Facebook and Google take some steps in this direction. Is this reconcilable? I've already suggested that moral rights might help us reconcile it, and that freedom of thought may be another mode of reconciliation. What's at stake? This is a sleeper. And it's very little talked about, and it really goes directly to Bury and freedom of thought. And you have to kind of look deeply at yourself. If you don't have privacy, if you feel you might be surveilled, how much does that chill your expression? That's where the core to the answer is going to lie. I don't think there's any doubt that it chills expression. How much, how, what are the modalities? What will make you feel less chilled? How do we legalize that? Just lots of material here, lots of articles. If you're doing a paper on privacy, a bunch of very good academic links, various papers, which you could go through at your length, at your leisure, not at your length. I do want to point out that there is some really good current work, like this semester current work, being done on privacy legal theories, because the issue is really joined now. So I've given you a series of links here, Privacy in Public by Joel Reidenberg. This one I love. James Whitman of Yale, The Two Western Cultures of Privacy, Dignity versus Liberty. And what it points out in short form is that we are not at Edom between Europe and North America on the purpose of privacy. And that's one of the obstacles in dealing with concepts of privacy and surveillance legally, because we don't see the core purpose the same way, and that in Europe, European norms are founded in dignity and personal honor. So think of the Spanish case. I actually paid my debt. That's about personal dignity, about personal honor. And the North American concept is liberty, is freedom. I should be free to say, think, and do whatever I want. It's not about my honor, it's about my rights. And until that gets bridged or gets better understood, you kind of have a bifurcated world on privacy surveillance issues. And even in this area, there's Paul Ohm's piece on sensitive information, and I already did Reidenberg. So we've come to the end. Sorry, had to do that. We're going to take a break and switch over. I hope that the Oculus experience was a good one and an interesting one. I look forward to hearing about it. And we are now going to get Jazz Purawal from London on the line, as it were. So take a 2-minute break. How'd it go? Great. Sure. So you're going to get Jazz?
Yep.
And I'm going to do a very quick piece here.
Thanks, everyone. We're done here. The second half of this class is going to be down in the classroom.
Sure. Did you find it interesting? That's my question.
Yeah, absolutely. Yeah,
Good.
I love.
And there's a lot of different theories. I think I could make it. I mean, I'm
Welcome to Blue Jeans. To connect to the meeting using your...
Oh, what was that? That's not supposed to happen. Let's do that again.
Welcome to Blue Jeans. To connect to the meeting using your remote... If you're a participant, please wait.
Can you hear us all right, Jess?
Yes, I can. Can you hear me?
Yeah, fine. Could you try sharing your desktop, please?
Yeah, sure.
Thank you. Okay, there it is. Okay, thank you, Jess.
Welcome.
We're hooked up. Jazz! Can you hear me?
Hello. I hear a familiar voice.
Sorry, I just want to get the inset for you. Do you want the inset for the class?
Yeah,
so
I
can see
do.
it?
Yeah.
Okay.
Sorry.
Sure.
There, it's up there.
Oh, it is.
It is up there.
Okay, good.
All right. Jazz, can you hear me?
Yeah, they did say that.
All right. You are the...
Make sure you turn your mic off and start talking. Leave it on for now while you're
Okay.
speaking to him.
You are the second part of a very tech-heavy class. The first part of the class happened, half the students took it through an Oculus Rift in another part of the law school. So,
Wow.
So we're today's a very, very tech-heavy day. I'm going to turn it over to you. Everybody has seen your bio. Jazz is merely the best video game lawyer in the world in a corporate sense. We had Jennifer Kelly here a couple of weeks ago, so I have to.
And she is the best.
I have to keep the litigation part, and we talked about you, in fact. So without further ado, Jazz Purewall coming to us from somewhere in London, England, on international law aspects of video game law.
Hello, everyone. You can all hear me okay still, right? Yeah, wave your hands if you can hear me. Grand. Hello. So I'm Jazz Purewall. I'm an interactive entertainment lawyer, and I'm dialing into you folks from merry old England. It's very nice to speak with you folks in British Columbia. As it happened, last week I was in Bogota, Colombia, and I noticed the sheer amount of people and souvenirs and so forth, which went to great pains to point out it was Colombia with an O, not Colombia with a U, and they didn't want to have anything to do with Colombia, which was spelled with a U. I was kind of puzzled, and so anyway, it's nice to speak with a different kind of Colombia rather than the Colombia I was at last week. I'm going to talk about 5 things with you folks. 5 things which I thought were particularly interesting in interactive entertainment law. They're by no means all of the cutting edge issues, but they're the ones which I as a practitioner are coming across more and more, and ones which in their own ways raise interesting issues of law which are both practical as well as academic. And those are the 5 which I've listed there, which I'm going to talk about: data protection, free-to-play regulation, first sale issues, the increasing phenomena of let's play and live streaming of games, and finally a little about regulation more generally. So a few words about me. I've been a games lawyer for about 10 years in London and Europe, and as well as in Silicon Valley. Last year I lived in California for a while, advising games and tech companies on the West Coast. I came back from big city practice and have set up my own firm which focuses upon interactive entertainment law. I also write a blog called Gamer Law, and here's some of the folks in the games industry with whom I work regularly, both in Silicon Valley as well as in the European Union. So, enough about me and the spiel about me. Let's kick into the first of the 5 topics I think is interesting in interactive entertainment law internationally. And the first is data protection. Well, in the European Union, it's called data protection. Elsewhere, especially in North America, it tends to be called data privacy. So, because this is sometimes seen as quite a dry topic, I thought I'd start with why it's impacting on games companies and then talk about the law afterwards. So, video games are subject to both United States as well as European Union regulation on data privacy, as well, of course, as many other Western markets, including Canada. But I mentioned the US and the EU as the largest of the Western games markets. And this has had an impact increasingly upon game studios. So Playdom, which is now owned by Disney, was fined $3 million in 2011 for breaches of the US Children's Online Privacy Protection Act, which I'm going to talk about a little bit later. In the course of 2012-2013, Sony had a series of attacks upon the PlayStation network, both in the EU and the US. That led to a series of fines, and I've mentioned as an example, in my home territory, the UK, there was a fine of £250,000, so about $400,000 just in one member state of the European Union over the PlayStation network attacks. Much more recently, the most recent example of fines for data protection non-compliance has been against the San Francisco-based mobile and social games company TinyCo, which was fined $300,000, again in relation to copper breaches by the Federal Trade Commission, essentially because they hadn't paid any attention, or so the FTC found, to many privacy protections. They were just gathering whatever data they felt like. They stopped this. They stopped in around about 2012 or 2013, I think, but it didn't save them from the FTC investigating historic allegations of data privacy breaches and fining them over $250,000, which isn't as much as Playdom was fined, but Playdom and Disney are a much larger concern, and TinyCo is really a game startup, so it was quite a significant deal. And zooming out to the macro level, there are a number of investigations and lawsuits taking place in multiple jurisdictions, not just the US and the EU, against the big tech and software platforms, including Amazon and Google and so forth. And all of that has an impact at a wider macro level for the games industry, because what happens to the platforms really follows through to games companies sooner or later. And that's one of the themes which we'll touch upon in a number of the points which I'm going to talk about during this presentation, that what happens to Apple and Google in particular, it matters for the rest of the games industry, even though at first sight, the rest of the games industry isn't really under investigation. So it has a bite, and it's having more and more of a bite over time from a dollars and cents perspective for data privacy legislation. Where that's coming from is a series of reports and findings and even new legislation in the United States and the European Union. So the FTC has issued at least 2, I think it's now actually up to 4 reports, which have differing levels of impact on data privacy in mobile apps, for children's services, and also now explicitly for interactive entertainment. And those make for really interesting reading. And similarly, in the European Union, there's a very influential body called the Article 29 Working Party, which is typical EU bureaucracy legalese for effectively the representatives of each of the 28 member states' data protection bodies all getting together. They tend to be a very conservative body and put together a very influential opinion on mobile privacy, which included games in 2013, which, if it was fully enacted, would lead to huge changes in the way in which mobile games in particular, but all games, can gather data. And that's all feeding through to different legislative proposals. So there have been some changes to COPPA recently in the United States, which have made things more difficult for games, especially mobile games. There are proposals at the state level all the time in the United States, which would tighten up data privacy rules in relation to all software, including games. And the European Union is in the process of changing what is already a very stringent system, the most stringent data privacy system in the world, in the process of making that even more comprehensive. And that argument has been going back and forth and involved many, many millions of dollars of lobbying money from US tech companies and games companies. And we'll probably see the fruits of that during the course of next year. We'll have to see at that stage what impact that has on the global games industry.
Jazz,
but the point is, sorry, John.
Can I just ask you one question, almost on behalf of the class? Can you just briefly address, we know that in some cases, when it comes to copyright law gets trumped by end-user license agreements. Can you describe the relationship between end-user license agreements in gaming end-user license agreements and privacy? Because many of those agreements, many of which you drafted, give very broad rights to the developer. And how does that interface with the privacy rules that are evolving? And then, of course, the wild card, what do you do about minors? And do you have a prediction on how this is all going to go?
It's a really good question. Let me tackle the next slide, and then I'll answer that question. And then at the end of the presentation, I was going to talk a little bit about terms and conditions, and so we will revisit the dratted question, the damn question of T's and C's, which never seems to depart the software industry, including games.
Perfect.
So what I was going to explain in the next slide, which adds a little more detail to what John was asking, is the question of, well, why does this matter? We know that data privacy is rising up on the regulatory agenda. We know that games companies in both sides of the pond are actually now being fined and are being investigated by the regulators. But nonetheless, so what? Why does this actually matter to games companies? Well, the reason is that all modern games with any online component are built on the collection of data. So if you have an online game such as, say, World of Warcraft or World of Tanks, or a mobile game such as Clash of Clans or Candy Crush, they're all built on collecting huge rafts of data. Now, for a start, you'll have to have a user account, which normally involves at least collecting the name, the IP address, your email address, some sort of avatar. Many different elements of that are personal data. Sometimes optionally it might contain one's age, gender, all kinds of other information, all of which is potentially personal data under US, EU, Canadian and other Commonwealth jurisdictions laws, which means that there are certain obligations that games companies have got to follow. And even if the information is not actually identifying an individual, it might nonetheless fall under data protection legislation in different parts of the world. So, for example, in the European Union, even if a piece of information doesn't identify an individual, if it's collected in the right kind of way, for example, using a cookie on a website or some other tracking technology on a mobile device, then it's still regulated, and so you have to get the appropriate consents and so forth. So, for example, tracking user behavior or monetization or advertising, all of this requires data. Now, what the tech and the games industry tend to say is, but that's all anonymized, and so it doesn't matter. The problem is that in the United States, regulators are increasingly skeptical as to whether it is actually anonymized or not, whether it can be reverse engineered. The regulators on both sides of the pond are concerned that the information is then warehoused and just sits there waiting to be leaked, which is exactly what happened with the Sony PlayStation Network attack, when it turned out that actually Sony had millions and millions of users' information sitting unencrypted, whether they were a registered user or not, just waiting to be leaked. And in the European Union in particular, there's just a very different approach to things, which says the way that you gather information is just as regulated as what that information is. And that's different to the United States, and it sets up one of the many legal battles which is ongoing between the two largest trading blocs in the world. Data privacy is one of those battlegrounds. Now, one of the main ways in which games companies and software companies can try to get around these issues is via the privacy policy, because that is right now one of the best ways we've got of trying to get consent. But the problem is, and I think this gets into what John was talking about, it's somewhat erroneous. I mean, it's a bit of a legal fiction to think that terms and conditions and privacy policies really gain consent. And they certainly, in most cases, don't gain the requirement in the European Union, which is for what's called real informed consent. It just doesn't really work like that. I mean, it worked back in the days of Commonwealth jurisprudence where if there were terms and conditions, then you were taken as being bound by it if you had reasonable notice. So going back to a 19th century English law case called Parker and Southeastern Railways, where if a train ticket said we've got terms and conditions, you were bound by it because you could have gone to go and check it. That's not the way that things have worked in consumer law over the last few years. But there's still a lag. We don't really have that authoritative case in the United States or the European Union which says we are rolling back more than a century of case law which says you are bound if you could have paid attention to these T's and C's. It's happening, and it's certainly happening more in the European Union where there is specific legislation that says any consumer document which results in an imbalance between the bargaining position of the games company and the consumer is invalid. If there's any significant imbalance which favours the games developer over the consumer and the consumer doesn't know and hasn't agreed to it, that's just not valid at all. It's a very stringent position. But in the absence of there being clear rulings applying those kinds of laws to privacy policies and terms and conditions, on the whole, the games developer or the software developer tries to get away with whatever they can. And so many of these documents tend to be full of legalese, and they say you consent to X and Y and Z. And as I said, until such time as we have more authoritative and activist rulings by the investigators, that's the position by default that most of the games industry is following, if they bother with privacy policies at all. In the United States, privacy policies tend to be the be-all and end-all. There isn't too much more you've got to think about. There's no central registration. There's no particular requirements that you have to follow and say on your website that you're following or things like that. It's different in the European Union. And so one of the biggest problems which a company in North America, which is expanding into the EU or elsewhere, has to think about, is that there are more formalities you've got to think about. But by and large, everyone still has a big legalistic privacy policy and hopes that that will get them through. So as to the last part of John's question about where I think that's going, I don't think that's sustainable for very much longer. And I think we're going to have to think about better ways to educate consumers about privacy matters than just a great big long privacy policy. And if it is going to be a privacy policy, it needs to be in plain language. I think it's just a matter of time before we have some fairly influential rulings upon that point, but we'll have to wait and see. So I'm going to move on quickly as time is pressing and we're only on point number 1. So I'm going to move on to first sale issues. So first sale is the principle in both EU and US law, and it applies in other jurisdictions as well, especially in the Commonwealth, that once a product has been distributed for the first time for value, that, say for example, a game, then the games developer loses the ability to control distribution of it once it's entered the market. And the idea is essentially it's a bargain with society. The games developer says, I'm releasing this game, I get to choose when and how and where it's released for how much money because I made it and I want to profit from it. And society says in response, well, that's fine, but once it's out into the marketplace, you can't control it forever because then that starts restricting the freedom of consumers and other businesses to trade upon the goods. So you only get a first bite of the cherry. You can't control what happens in the aftermarket. And so that's one of the reasons, for example, that once a book publisher has sold a book in a store, then they can't control what happens if the customer wants to resell it, for example, or they want to give it to charity or things like that. All this is an increasingly hot issue in software and games because it's basically getting at the question, once I've bought a game, what can I do with it? Can I sell it to GameStop if I want to sell it to GameStop? There are different answers in the EU and the US, and the whole thing's becoming a bit of a mess, unfortunately, from a legal perspective. But I'm going to talk very briefly about what's happened in the EU, then what's happened in the US, and then why this is a mess. The case law at the European Union level, so at the federal level, if you will, at the EU, and it was actually an enterprise case a couple of years ago now between Oracle, the enterprise software company, and a competitor of theirs called Usoft. Basically what would happen was Oracle was offering digital downloads of some of its enterprise software via a license key, And Usoft, what they were doing is they were reselling those software licenses, which was effectively cutting into Oracle's market, because you could buy cheaper from Usoft rather than buying direct from Oracle. Now, Oracle weren't particularly fans of that, and so they decided to sue in Germany, and it went all the way up to the Court of Justice of the European Union, which is the highest court in the EU. And so the questions were, effectively, can Oracle stop someone from reselling software licenses forever, or does the first sale principle mean that once Oracle has first sold the software, it can't control what happens, including software resale? So none of this was explicitly talking about games, but you can see where it's going in terms of its overall application to both physical copies of games as well as digital copies of games on, say, for example, the Steam or the Xbox Live platforms. So the questions that were asked in the Usoft case were, does downloading software mean that the first sale right is exhausted, which means that the person that bought it can go and sell it off in the marketplace if they want? And the answer to that was yes in the European Union. So does that mean that the subsequent purchaser is permitted or is it banned from downloading and using that software? And the answer was yes, that's right. And could Oracle use its IP rights to restrain second-hand sales? And the answer was surprisingly yes. It all seemed a bit confusing because those different answers seemed to contradict each other. Taking a step back, what the Court of Justice of the European Union said was, once you, a proper commercial entity, have released valuable software into the European Union, and that's out and it's free and it's in the wild, and if in practice what you are doing is selling software, not a license, then that's a product, a thing in its own right, which can be alienated for value, and you can't control it. If Usoft or any other company wants to go and resell it in the future and customers are willing to pay for it, then that's fine. And in particular, it was a very activist ruling in which the Court of Justice of the European Union was trying to envisage a different way, a more consumer-focused way of selling software, which the CJEU was well known as an aside for activist rulings which basically set new law without actually bothering to go through legislation. So this was nothing new for them. But it was a ruling which was riddled with all kinds of errors, even though clearly what they wanted to do was to introduce the principle that you could resell software in the European Union, including games. And it led to a whole different series of problems. I just listed some of them here. I won't go through all of them, but the case seemed to apply to both digital and physical copies. It didn't quite explain what happens if I, for example, have a copy of say Call of Duty Advanced Warfare and I decide to give it to you. What happens to the copy that I had installed on my system? Can I still use that? And the CJEU said, no, you can't. You've got to get rid of it somehow. So then the question was asked, well, how does that happen? And the CJEU didn't really have an answer for it, apart from saying maybe you can use product keys, which will only to be used on one system, which might be a way around it for games companies. And then they said, well, what Oracle tried to argue was, but what about our IP rights? Because a piece of software is not just the physical thing, it's not just the installer, it's also the IP rights which underlie that, which are separate from the physical thing. Can we try and use our legal rights to stop resale of the content? And that's the way that traditionally the software industry has tried to approach things. You can have the disk, but you can't have the software that's on it. And the CJEU didn't really have an answer for that, apart from to say, if that's going to interfere with consumers' rights to resell software and games, then we're not happy with it. So you can see from just that very quick summary that we wanted to have the principle in the EU that you can resell games and software, but there were lots and lots of problems with how you actually achieve that. So back in 2012, 2013, we were all a bit confused about exactly what that meant, and certainly the games publishers were too. So since then, there have been a couple of test cases which are even more confusing than you would imagine than the original case suggested. Both of them have been in Germany. In 2013, the consumer watchdog in Germany, the VZBW, sued Valve as a result of the Usoft ruling. This was actually the second time that VZBW had sued Valve. They'd sued them in 2010, saying you have to permit Steam users to sell games which they don't want on Steam. And I'm assuming that you guys all know what Steam is, but just in case you don't, it's the largest PC digital download platform and one of the largest digital download platforms in video games, full stop. And it has about 95% of the PC download market in the US, probably around about 70 to 80% of it in the European Union, and it's probably got revenue of about $2.5 to $3 billion a year, so it's a big beast. So what they were trying to prove in Germany was a test case to say you have to allow users to resell purely digital copies of games. They failed on that argument in 2010, and after the Ubisoft case they had another go. So far, the argument in the German court applying the EU principles has been, no, that's not right. The argument was that the Ubisoft case applies to computer software, but games aren't just computer software, they're something more than that. It's difficult to know exactly what they are, but there seemed to be an argument that video games are both to be considered audiovisual art, and they will also be considered computer software at the same time. So that would have been a really interesting test case had it come to pass, but it didn't. More recently, one of the large European publishers, a business called Koch Media, took legal action against a series of companies which were reselling the product keys from their games. Basically what they were doing is importing copies of Koch video games such as Dead Island and the latest Saints Row game, importing them from Russia and China and elsewhere, stripping out the CD keys and selling the CD keys at a profit within the European Union. So the argument which those different resellers came up with is Ubisoft says that we can do that. That's an interesting test case because if that principle stood, then there'd be a decent argument by any product key reseller that they can basically resell games at any price they like and you don't have to go to a publisher to buy them at full price. And again, the German court held no, Ubisoft does not allow you to resell games in that way. There are at least a couple of other cases which are ongoing within the European Union. So, on the face of it, you have a rather puzzling position in the EU. The highest court in the European Union wants to allow consumers to be able to resell games once it's been sold to them for value in the first place. But so far, the courts which are applying those rules, in particular in Germany, are adopting a rather more activist stance. And I really do not know what the current state of play is. I mean, the fact that the highest court in the EU had an activist ruling and they wanted to change the law has got to mean something, but so far the lower courts are openly defying them. So we'll have to wait until there is another case going up to the CJEU before we really know what the position is going to be. But in the meantime, most of the games publishers are sitting on their hands, hoping against hope that this doesn't happen because they have no idea how it's going to influence the PC market, but also the mobile apps market. Imagine a world in which in the course of the next year or so, you could resell your mobile apps if you no longer wanted them. Imagine a world in which you could even sell back your virtual goods within, say, Clash of Clans or Candy Crush if you no longer wanted them. It would be a huge sea change in the way that modern games work. But at present, we don't have the exact authority for it, at least in the EU. Moving on very briefly to what's happened in the US, we have explicit wording regarding first sale in the US, in US legislation, in US Code Section 109. You can see the wording there. That's the wording from which the first sale doctrine is derived in the United States. There's earlier case law than Ubisoft in the US, a case called Werner and Autodesk in 2010. Very similar kind of situation. An individual, Timothy Werner, was buying graphics software released by AutoCAD, and he was selling them on eBay. Basically, he was selling older copies of the software which people still wanted access to rather than the latest version, and he was doing it much cheaper. Again, as with Oracle and Ubisoft, Autodesk wasn't terribly happy with what they perceived as someone cutting into their market, and so they sued. The key question was whether Autodesk could actually restrain Timothy Werner from carrying out resale of used software, or because of the first sale principle, or whether actually the first sale principle was not exhausted, and so Autodesk still had rights in their software, even though it was being sold on the open marketplace. Now, what happened here was that the court focused, in my view, on the form of the transaction, not on its substance. They looked at the end-user license agreement, and they said, well, has Autodesk specified that only a license is granted? Yes, it did. Did that end-user license agreement significantly restrict the user's ability to transfer the digital product? Yes, it did, because the end-user license agreement in some detail said you can't do X and Y and Z and so forth. As a minor aside, I apologise. I said X and Y and Z earlier, forgetting, of course, that I'm with the Canadian. It's Z, of course, as it properly should be. So, did the end user license agreement block X and Y and Z about how you can loan and transfer and rent the software and so forth? Yes, it did. It said you can't do any of those things. And finally, did it impose any other use restrictions? And yes, there was any kind of use restriction you can think of under the sun, because this was the kind of end-user license agreement where Autodesk's lawyers had thrown the book at it. The court looked at all of that, and they said that as a result, Autodesk was licensing to its direct customers. It wasn't selling software as a good to their customers. And therefore, Timothy Werner could not resell software on eBay because he'd never had title to it in the first place, which is the kind of ruling that software companies have always hoped would be passed, because that's what their end-user license agreements were always based upon. And that's always been the central point of difficulty regarding end-user license agreements from a substantive perspective with consumers, leaving aside all the form and the fact that no one ever reads them. The legal difficulty between an end-user license agreement and a consumer is a consumer thinks they're getting something when they pay money for it. But the legal fiction is, no, all you're getting is license rights, you don't have ownership rights. That's the argument that Autodesk put forward, and that's the argument that the Ninth Circuit, at least in the US, agreed with. And therefore, bye-bye Timothy Werner, you're not selling anything, and not only that, you've got to pay damages to Autodesk for what you have attempted to sell in the past. Now, since then, and prior to that, there have been a whole series of rulings in different parts of the US which haven't always necessarily agreed with them. And I'm going to highlight in particular the case of Kurtzang, which took place later on. That was an individual who was actually a foreign national but studying in the United States, who was having books imported for his courses by members of his family so that he could read them and use them cheaper than if he'd bought them in the United States. And he realized he was onto a good thing here because his family was acquiring them at a cheaper price than in the US. And so he made a little business out of this. Now, one of the publishers, I believe it was one of the publishers called John Wiley & Sons, got wind of this and sued him. And what was decided there in the Kurtzang case was actually books which were manufactured and imported from outside of the US were protected by the first sale doctrine, and effectively, therefore, he could resell them if he so chose. And that, on the face of it, seemed directly at odds with Werner and Autodesk, and has been discussed as such in many of the journals since then. A case which, last I looked at it, was still ongoing, although it may have settled by now, Redigi, was a case involving music lockers, and many of the same principles came up. And there the arguments were that it wasn't covered by the first sale doctrine following a Werner-type approach. So the point is that there's been different arguments back and forth about, first of all, does first sale apply? Secondly, should we apply a formal test to end-user license agreements or a substantive test to end-user license agreements? I should mention just in passing the MTY and Blizzard case, that the so-called WoW Glider case, which was one of a series of cases that Blizzard took against bots which were being sold for profit in World of Warcraft. That was a case where Blizzard pointed to the court the terms of its end-user license agreement, which said World of Warcraft is licensed, not sold, and you can't do X, Y, Z. And the court just took it at face value and said, yes, that's fine. And MTY Industries was arguing, well, that's not fair, because actually there are lots of things that customers ought to be able to do. And if customers want to use software which helps them to accelerate in the game, then they should be able to do it because they paid for it, they get it. The court didn't agree with that and applied a formal rather than a substantive test. So the position on the whole seems to be a little bit more favourable to software companies and games companies in the US than it does in the EU. Looking at it more generally, I think we have a recipe for confusion here. The EU seems to be open, albeit in a rather confused way, to permitting second-hand sales of software and games. The US seems to be moving to prohibiting them, apart from in specific circumstances. So Kurtzang may be construed as applying only to books, or may be distinguished from its circumstances somehow, but the authority still stands one way or the other, and there's a chain of case law which seems to be applying a formalistic view rather than a substantive view of end-user license agreements, which also helps to argue against second-hand sales. So we have one part of the Western games market saying one thing, maybe, and we have another part of the Western games market saying something else. And I have no idea where this is going to end up. It's entirely possible less likely than it was a few years ago, but still entirely possible, that the European Union will say you can resell games if you want to, and the United States will say you can't resell games even if you want to. And that is going to set up all kinds of consumer issues in the future, and quite possibly further lawsuits. And we'll have to see how things go. But there's a lot of money at stake here, because games resales are often said to be a large issue and also a large opportunity for games companies.
Can I just interrupt for a second to point out that there's one other aspect of this of interest to the class, and that although it's a staple subject, this is a wonderful subject for all the reasons that Jazz has expounded for term papers. And it comes up frequently, but this is always a great term paper because we don't know what the Canadian position might be, and it often, as you know, is halfway between the European or English position and the American position. So we're predicting what our Supreme Court of Canada might do here is, at the very least, a wonderful term paper.
And as far as international positions are concerned, one thing I'd emphasise, and I always try to emphasise with these kinds of talks, is the Canadian position matters to the UK position, and it matters by extension, therefore, to the European Union position, because British courts often have great regard to Commonwealth case law, in particular in Canada and Australia. And so if there was a clarification of the position in Canada, that would have weight on the English law position as well, and vice versa. So I'm equally interested in where things in Canada go, because that has an impact on my country legal position too. So that's that. A couple of words, I guess, in closing about does this really matter? Because we can, as one client put it to me recently, you can get kind of over-bothered by this kind of thing. But on the whole, what dollars and cents or pounds and pennies impact does it have? Well, first of all, we don't know for sure that there is considerable customer demand to resell games. There is one platform I'm aware, which explicitly permits second-hand sales of digital games, and that's a company which originally was set up in the UK called Green Man Gaming, and that's done moderately well. It's become a fairly successful platform. It's expanded into the US and the EU, and the whole model is you can resell your games back to us if you don't like it. But it hasn't had anything like the growth that Steam has had, so maybe that says something about whether customers are willing to vote with their feet on this issue. Secondly, it's been rumoured for quite some time that a number of the platforms are planning to ready their own trading platforms already. Steam, for example, has a limited gifting platform. They have an explicit trading platform for trading cards and things like that. The one missing piece of the jigsaw puzzle is trading of games. I would hazard a guess that will happen eventually, but it hasn't happened yet. It's also worth saying that, counter to the point about customers voting with their feet, Microsoft got a hell of a lot of stick about a year and a half ago when they announced that Xbox One would have certain mechanisms which would restrict second-hand sales, and they've subsequently ditched those. And Sony made a lot of hay by being able to argue that the Sony PlayStation 4 wouldn't have any of those restrictions. So maybe that's an argument that actually customers were concerned about this. But nonetheless, I would hazard a guess that if there was research about how many people actually wanted to sell digital copies of their games on Xbox and PlayStation, it would be pretty indifferent. The other point to mention is that there's a danger this could be seen as a solely Western issue. It's not. I mean, the greatest growth in the games industry is going to come from outside of North America and the European Union, and China and Latin America just don't have these problems. I mean, they have a whole bunch of other problems, but this is not one of them. And finally, changes in business models may change things. We've been talking about the growth of cloud gaming for at least 4 or 5 years now. It hasn't really come to fruition, but it's still getting there. And if and when we ever move to a position where the major games are consumed on a subscription basis rather than an ownership basis, then the question of first sale doesn't arise, because you were never buying anything in the first place. All you were doing is buying a subscription. So, for example, you may be aware that EA is trying to adopt this with what they call EA Access, which is a subscription fee of, I think, about $9.99 a month, both dollars and British pounds, in return for access to a big library of content. Sony will be doing the same thing with PlayStation. I think it's called PlayStation Now, which is rolling out quite soon. But that doesn't have a first sale issue at all. I mean, it has other problems because lots of consumers aren't happy with subscriptions for various reasons, but we'll have to see what happens. So, enough about that. On to a different subject, one which is largely European, really. So, with free-to-play games, raise your hands if you don't know what a free-to-play game is. Okay, one or two hands, so it's worth explaining, therefore. Free-to-play is a business model which the games industry has pioneered recently. The concept is that you don't pay anything at all in order to play a game up front. So unlike, for example, the latest Call of Duty game, which is up to $60 US to buy and then install, you wouldn't charge anything to play, for example, Candy Crush Saga on your iPhone. Instead, the way that the game makes money is by incentivizing you to spend small amounts of money as part of the game experience. So, for example, you're playing the puzzle game Candy Crush Saga, and if you have a particularly difficult level, then you may spend a few dollars or pounds or yen or whatever in order to make it easier for you or to enjoy the experience in some other way. Or maybe, for example, in a different game, you want your avatar to wear a different hat. That's all stuff which you charge for, which you're charged for as part of your experience of the game. You're not charged anything to play it in the first place. And this has been tremendously successful because it removes a huge barrier to entry and it opens up the potential game-playing audience massively because people that would have been put off by the idea of spending on something, that barrier is removed. The problem is that it's a very underregulated area and there's been increasing concern about what the proper regulation of this business model should be, bearing in mind that it's never really existed before and it's really the nature of games as an interactive medium which permits them. You can't really have the free-to-play business model with film or music because it's essentially a linear medium. Either you watch the film or you don't watch the film and there's a start and a fixed end point. So the only meaningful way that you can make money from it is to charge you to watch the film. But by contrast, games involve an ongoing relationship, and so you can monetize that rather than try and monetize people getting in the door in the first place. But how should that be regulated legally? Those points, this is becoming increasingly rising up on the regulator's agenda because two things are becoming linked. One is children's use of new games platforms, especially mobile, and the second is the rise of the free-to-play business model. Now, those are not the same things. Just because you have free-to-play games doesn't mean that somehow children are going to be the only people that are using them. But nonetheless, we're getting increasing calls of, we must protect the kids. There is some regulation of free-to-play games already in the sense that there's a background of regulation for games more generally, such as privacy law and advertising law and age ratings and things like that. But the question is that existing background thicket of law enough, or should there be a specific body of law regulating free-to-play games? Now, there's been some moves to self-regulation on it already, by far on mobile, because it's mobile that really has done the best out of free-to-play games. So, for example, 2 or 3 years ago, you wouldn't know when you downloaded an app on iOS, Apple iOS, whether it was free to play or not, whether it had in-app purchases, and now it does. So, for example, with Angry Birds Star Wars, there you had to pay 99 cents, but now with the latest Angry Birds game, Angry Birds Transformers, it's free to download, but there'll be a little sign that will say offers in-app purchases. That's a change which Apple made in order to ward off regulation. Similarly, they have activated more and more stringent controls for parents to control how in-app purchasing takes place on Apple. Google has done, until recently, quite a lot less, but they did have a family mode. Microsoft has set up a kids corner. BlackBerry had similar rules, but it was all fairly tech-led attempts to try and get at this issue of we must protect the kids. In the meantime, the media calls for that have been growing shriller and shriller. So, for example, here's 2 articles I found. The Wall Street Journal one was a little bit tongue-in-cheek. Mom, please feed my apps. And it was leading off various consumer reports. One mother who sued Disney because her child had allegedly spent $1,400, aged about 6, on the mobile game Smurf Village, and she said, how dare you not have appropriate controls. A rather more educated and very interesting view on this was written by a journalist called Rob Farhay on games industry. I've written the article, I've given a screenshot of the article there, called How to Control Free-to-Play Spending. The point is, both in the mainstream press and the games press, these issues have been ventilated. Those articles were in 2012 and 2013 respectively, and the regulators have been listening. So there's been regulation in Japan, there's been some investigations but no explicit action yet in the United States, with some reports being published by the FTC specifically on mobile and mobile apps. Age ratings have been rolled out by the ratings bodies in the US and the EU, allegedly referring to in-app purchasing but not really doing much, but at least the issue's there. The thing that's most interesting, though, is regulation in the United States, regulation in the European Union and the UK. This is the world's first explicit regulation of free-to-play games. So what happened is, in late 2013, the UK's consumer protection regulator says, we're going to investigate free-to-play games to make sure, initially, that they protect children, but the remit of the investigation was later expanded to any free-to-play game, whether they covered kids or they applied to kids or not. Not to be upstaged, the European Commission, which is the main enforcement body of the European Union, announced that they were going to carry out an investigation as well. So we had two different investigations going on within the EU, which arrived at different results. The UK published 8 principles for free-to-play games, which they said were effectively a model for the rest of the European Union to follow, and which any games company worldwide which was releasing free-to-play games in the EU should follow. Fairly sensible, and they tend to be focused on formalistic things rather than much more difficult questions about whether gameplay mechanics should be fair, whether they should monetize up to a certain limit, things like that. They were much more focused upon, does it look sensible, is it misleading, does it have T's and C's, that kind of stuff. And eventually the European Commission came up with the results of their findings as well, but they focused much more upon Google and upon Apple. They were focused upon the platforms. And their argument, going back to what I was saying earlier, is that if you focus upon the platforms, that's much more likely to have an impact rather than on individual games companies. So we therefore have EU consumer protection law being enforced much more stringently for the first time against free-to-play games companies. A game cannot call itself free if it's not. It can't be misleading, it has to provide material information to gamers, you have to be careful, very careful when you're marketing to children, you have to have terms and conditions in place, which is the first time the games have explicitly been told you must have terms and conditions in place, and generally you're meant to be thinking consumer. Exactly what that means and how stringently it applies, we're still trying to work out. There haven't been enforcement actions so far, at least in relation to these rules. But the issue is still percolating there in the EU, and we can't just assume it will just be a formal test rather than substantive review. So, for example...
Jazz, I'm just going to give you a time check. You've got under 5 minutes.
I should be very quick in that case. Although the rules so far, as I say, we're looking at formal type stuff, you then had a rather more unwelcome development in the UK recently. The latest reincarnation of Dungeon Keeper, which is one of the great games of the 90s and 2000s, was investigated by one of the advertising regulators in the UK, which was really looking at the gameplay mechanics and saying it's just not reasonable that you make people wait so long before they can play the game unless they spend real money, which was an explicit review of the gameplay mechanics. So we can't exclude entirely the possibility that free-to-play games, which have been making so much money recently, may be subject to explicit rules in the future which talk about the gameplay mechanics and not just all the legal dressing around it. And again, that will have a really big impact on games, especially mobile games, if and when that comes to pass. So, T's and C's, again, in the few minutes I've got remaining. Is this okay? If you've all got iPhones, you'll see that from time to time, Apple says we've changed the terms and conditions, and it goes on for pages and pages on this tiny screen real estate, 51, 60 pages at a time, and all you can do is say yes, unless you're actually going to read the whole thing. It says it can send it to you by email, but even if it sends to you by email, you still have to agree to it there and then on the spot, otherwise you can't use your iPhone. Is that okay? This is the screen from the European games developer World of Tanks, a very successful online game. You'll see at the bottom that you have a little tick box which says I accept EULA, and that's a hyperlink to the end user license agreement. So you can quite happily tick it without actually opening it up. Is that okay? This is a screenshot from my own Steam account, and you can see how much money I've wasted on PC games in the past. Different games publishers will require you to agree to their terms and conditions before you can install the game. So this is an example of one of the Battlefield games by Electronic Arts. In order to install the game, you've got to agree to this, whether you like it or not. You scroll to the bottom, you say, I agree. Is that okay? Answer is we don't really know. Since the late 90s, we've had arguments about different forms of terms and conditions. Once they used to be written on a piece of paper that was stuck in the box, so-called box wrap. Then we had arguments that it was okay on a if you clicked a box, the click wrap. Now we have arguments that if you even just link it, link wrap, then that's enforceable somehow. This goes back to what I was talking about earlier on. Certainly the traditional English and Commonwealth law perspective, I think, would have been if it's there and you're given notice of it, you're bound by it whether you read it or not. The much more continental and activist approach is no, you've got to explain things to people, otherwise they're not bound. We still don't really have much an answer to it. We thought it was a resolved issue. It's clearly not a resolved issue. One of the reasons is mobile. It's a lot more people are doing e-commerce via mobile, and it's very hard to get to contractual enforcement methods, agreement methods, which are binding on that tiny real estate. There's many more regulators which are activists, and there used to be. They are tackling this issue. And we've also had pro-consumer legislation, especially in the EU. But I think this issue, which has been argued by contract lawyers and games lawyers for years and years now, hasn't gone away. And if anything, the inexorable rise of mobile means that it will come back to bite the games industry in the butt again sometime in the future. I've almost run out of time now. I'm going to say this real quickly in the few seconds I've got remaining. Let's Play. For those of you who aren't aware, there's been an enormous growth in a very strange phenomenon, which is people are willing to spend hours of time and spend lots of money to watch other people play games. That might be competitive gaming, such as esports tournaments, or it might be you just watching your favorite online personality playing a game because it's fun. So the fellow on the right, can anyone tell me who the fellow on the right is? The fellow called PewDiePie. Now, PewDiePie is a Swedish guy in his mid-20s. He is by far the most popular YouTuber ever. I mean, he beats everyone else. Every big company you can think of, hands down, this guy has more views per month. And what he does is he streams himself playing games and talking about games. And he's become extremely popular as a result. The icon at the bottom is for Twitch.tv. Now, Twitch is a video live streaming company. It basically provides software allowing people to stream themselves playing games in real time, tournaments and so forth. And it's become extremely popular. It's only about 3 years old, and it was just bought by Amazon for $975 million cash. So a very, very successful business. But this is new because it's video games, but it's broadcasted video games. So is it to be regulated by games law? Is it to be regulated by broadcast law? The problem with broadcast law is it's set up to focus on TVs, on TV companies, and it's just not really ready for digital. And there's a whole plethora of issues which are coming to the fore right now. One of the most common issues you'll see online being discussed in forums now is what happens if PewDiePie is being paid by Square Enix or Activision or EA in order to review the game. Should he disclose that? Does that introduce certain restrictions upon him? It starts getting into journalistic principles. On the face of it, I mean, it looks like an issue that might fade away, but the sheer amount of time and eyeballs that's going into this means that it's an issue from a practical perspective. And it does raise really interesting issues, which no games law, I think, really thought about until recently, which is the porous line between games and broadcasting law and TV and film more generally. So I see that as a very interesting topic, which there'll be much more on in the years to come.
I just want to point out that it's in the book, that it's in video game law. I do take it on in a Canadian context, so I'm glad to see that it has some relevance to the world, finally.
Indeed it does. So I've run out of time, and I apologise. I meant to finish a little earlier so that you could ask any questions that you might have. So if we still have time, John, I'm happy to answer a question or two.
Any questions? No questions, Jazz. Thank you so much. I did send you an email with a picture of what you looked like from the back of the class. So we really appreciate it. Fit incredibly well into the course. And you and I will talk soon.
Thank you very much. Have a nice day. Thanks.
All right. Please post Oculus reactions. I've asked for them online. How did it go?
Good. It was so good.
Was it so good?
Like quite an answer.